Dovete evitare di fare le riprese, l'ho già detto una volta, non è un cinematografo. Ci siamo? Perfetto, la votazione è chiusa. La Camera approva. 396 favorevoli, 99 contrari.
On the 28th of November 2018, the House of Parliament approved the Bill 842,018, the so-called Security and Immigration Decree, popularly known as Salvini's Decree, in the version in which it was amended and approved by the Senate on the 7th of November with 396 votes in favor. On the text the government had put trust. None of the more than 600 amendments presented by the opposition were discussed in the courtroom and in the committee, and the few amendments presented by the Five Star Movement were withdrawn. They voted in favor of the deputies of the League and Five Star Movement, Forza Italy and Brothers of Italy, while they voted against the Democratic Party. On November 26, the government decided to put trust on the norm to speed up the parliamentary process and approve it by December 3. Here's what changes and what are the critical issues of the reform that modifies different rules on asylum, immigration, citizenship and security. What the Security and Immigration Decree provides. Number 1. Abolition of humanitarian protection. The first article of the decree contains new provisions concerning the granting of asylum and in fact provides for the repeal of protection for humanitarian reasons, which was provided for by the Consolidated Law on Immigration. Before the law was converted into law, the police station granted a residence permit to foreign citizens who presented serious reasons, in particular of a humanitarian nature or resulting from constitutional or international obligations of the Italian state, or to people fleeing emergencies as conflicts, natural disasters or other particularly serious events in countries outside the European Union. Humanitarian protection was also recognized to foreign citizens who cannot be expelled, because they would have persecuted in the country Article 19 of the Immigration Act, or if they were victims of exploitation or trafficking. In these cases the permit had different characteristics. The duration was variable from 6 months to 2 years and was renewable. This protection was introduced in Italy in 1998. In 2017 in Italy 130,000 applications for international protection were presented, 52% of requests were rejected, 25% of the cases were granted humanitarian protection, 8% of the people were granted refugee status, another 8% obtained subsidiary protection, the remaining 7% obtained other types of protection. As highlighted by the researcher Matteo Villa of the Institute for International Policy Studies (ISPI), as of January 2018, asylum applications in Italy are decreasing. With the entry into force of the decree, this residence permit can no longer be granted, not even by the courts following an appeal for a refusal. The decree is not retroactive and therefore does not apply to those who have applied for asylum before October 5, the day it entered into force. Instead of humanitarian protection, a residence permit will be introduced for some special cases, that is for some categories of people, victims of domestic violence or serious work exploitation, for those in need of medical treatment because they are in a state health seriously compromised, or for those coming from a country that is in a situation of contingent and exceptional calamity. Finally, a residence permit is provided for those who have distinguished themselves for acts of particular civil value. This type of permit has a duration of 1 year and can be renewed. Following the elimination of humanitarian protection, therefore, all the cases in which, in the event of repatriation, the applicant risks inhuman or degrading treatment or simply prevents him from exercising the democratic freedoms guaranteed by the Italian Constitution and rights guaranteed internationally, explains the Italian Council for Refugees, CIR. A possible absence of protection for these cases would involve unconstitutionality, as well as violation of international treaties, underlines CIR, who recalls, among the states 24 of the 32 European countries provide for forms of protection similar to our humanitarian protection. As far as the member states alone are concerned, those who recognize a form of national protection for humanitarian reasons are 20 out of 28. Number 2. Extension of detention in the repatriation centers, CPERs. Foreigners who are held in repatriation centers, CPER, XCIE, waiting to be repatriated, with the new decree may be held for up to 180 days. Previously they could be held for a maximum of 90 days. Even asylum seekers may be detained in the CPERs waiting to be identified. Number 3. Holdings in hotspots and border crossings. Article 3 of the decree provides that asylum seekers may be held for a period of a maximum of 30 days in the so-called hotspots and in the first reception facilities, CAS and CARA, to ascertain their identity and citizenship. If identity is not established in the 30 days, asylum seekers may also be held in repatriation centers, CPER, for 180 days. So the asylum seeker can be held for 210 days only to verify and determine his identity, without having committed any crime. These measures will also apply to minors who are part of a family unit, points out the Italian Council for Refugees. On this point expressed his concerns the guarantor for the rights of childhood, Filomena Albano. Finally, Article 4 of the decree provides that the irregularities can be held in the border offices, if there is no availability of seats in the CPER, with the authorization of the Justice of Peace, at the request of the Commissioner, waiting to be repatriated with procedures to accompany the border. The decree also provides that if there is need, the Justice of Peace can authorize the stay, in appropriate premises, at the border office until the execution of the repatriation, but no later than 48 hours. CIR points out that in this case the bill does not refer to methods of detention or guarantees. The national guarantor of the rights of persons detained and deprived of personal liberty expressed strong concern for the provision of these new places of detention in terms of the structural inadequacy or the complete indeterminacy with consequent, objective impossibility of the national guarantor to exercise the own power and duty of access, visit and control. Number 4. More funds for repatriation. Article 6 provides for the allocation of more funds for repatriations, €500,000 in 2018, €1.5 million in 2019 and another €1.5 million in 2020. Number 5. Revocation or denial of international protection. The decree extends the list of crimes involving withdrawal of refugee status or subsidiary protection. This happens when the refugee is definitively convicted for some crimes such as threat or violence to a public official, serious and very serious personal injuries, female genital mutilation, aggravated theft, house theft and theft with tear. The application may also be suspended when the applicant is in a criminal proceeding for one of the offenses that would result in the refusal of asylum in the event of a final conviction. Furthermore, if the refugee returns to his country of origin, even temporarily, he will lose international and subsidiary protection. Number 6. Accelerated procedure before the Territorial Commission. In Article 10 the bill introduces an immediate proceeding before the Territorial Commission, the administrative authority that deals with the assessment of asylum applications. Those who are subjected to criminal proceedings for some types of crime, or have been convicted even in a non-definitive manner, are subjected to an immediate procedure before the Territorial Commission. The eventual appeal does not have suspensive effect and therefore the person can be immediately expelled. Number 7. The list of safe countries. With an amendment presented to the Senate, Article 7 bis was added to the bill providing for the establishment of the list of safe countries of origin and the procedure for the application for international protection that is manifestly unfounded. With the changes introduced, the Ministry of Foreign Affairs, together with the Ministry of Interior and Justice, establishes a list of safe countries of origin on the basis of information provided by the National Commission for the Right of Asylum and by European and international agencies, EASO, UNHCR, Council of Europe. An asylum seeker from one of the countries on the list will have to show that he has serious reasons justifying his asylum application, and his application for asylum will be examined in an accelerated manner. The CIR stresses that therefore there will be an inversion of the burden of proof, in contrast with the general principle that foresees a shared burden between the state and the asylum seeker. If the asylum seeker comes from one of the states on the list, his asylum application will be examined as a matter of priority and the deadlines will be doubled compared to those foreseen: 14 days for transmission to the Commission and 4 days for the decision. In addition, new hypotheses are introduced to qualify an asylum application as manifestly unfounded, in the case of citizens from countries of origin considered safe, people who have made inconsistent statements, people who have made false information or false documents, people who have refused to submit to the fingerprints, people who are in a situation of successful administrative expulsion, people who constitute a danger to order and security, foreigners entered the Italian territory in an irregular manner that did not immediately apply for asylum. In addition to the list of safe countries of origin, Article 10 of the decree speaks of the principle of internal flight, that is, if a foreign citizen can be repatriated in some areas of the country of origin where there are no risks of persecution, the request for international protection is rejected. This concept introduces strong discretion in examining asylum applications, and strongly limits the possibilities of protection for asylum seekers, says CIR, who drew up a form to explain all the changes to the decree. Number 8. Restriction of the reception system. The system for the reception of asylum seekers and refugees, SPRARE, the ordinary reception system that is managed by Italian municipalities, will be limited only to those who already hold international protection or to unaccompanied foreign minors. It will then be resized and will change its name. The other asylum seekers will be welcomed by the extraordinary centers CAS, and by CARA. Number 9. Exclusion from the registry of asylum seekers. Article 13 of the decree provides that asylum seekers cannot be registered in the registry and cannot therefore access the residence. Number 10. Revocation of citizenship. The bill introduces the possibility of revoking citizenship to those who acquired it: foreigner who acquired citizenship after 10 years of residence in Italy, stateless person who acquired citizenship after 5 years of residence in Italy, the son of foreigners born in Italy who has acquired citizenship after 18 years, a spouse of an Italian citizen, an adult foreigner who is adopted by an Italian citizen, in case he has committed some crimes related to terrorism. The revocation is possible within 3 years from the final conviction for crimes related to terrorism, by decree of the President of the Republic on the proposal of the Minister of the Interior. For the CIR, this standard creates 2 categories of citizens: those by birth to which it cannot be revoked, and those who have acquired it to which it can be revoked in a unilateral way. For this article, a profile of unconstitutionality according to Article 3 of the Constitution has been hypothesized. Many analysts have stressed that this rule can favor the creation of stateless persons in contrast with the prohibition of new statelessness provided for in Article 8 of the Convention on the Reduction of Statelessness adopted on August 30, 1961, to which Italy joined in 2015. In addition, the deadline for the conclusion of the procedures for granting citizenship has been extended from 24 months to 48 months. Please use the comment section for more information. Thank you for watching Diaspora Facts. Please subscribe.